This video very briefly looks at the law relating to sexual harassment at the Australian level. You'll see that there are provisions in relation to sexual harassment in both the Commonwealth and state level anti-discrimination legislation. Here is our definition of sexual harassment for Queensland. It's a little bit more detailed than the Commonwealth one. The meaning of sexual harassment under the Anti-Discrimination Act, Queensland, is something that happens where a person subjects another person to an unsolicited act of physical intimacy. And notice it's an unsolicited act. We're not looking at whether a person has to decide whether or not it's unwelcome at the Queensland level. It's something where if someone touches you without you asking them to do that, then that would be sufficient to be unsolicited. Makes an unsolicited demand or request, whether directly or by implication, for sexual favours, where the discriminating person makes a remark with sexual connotations, engages in other unwelcome conduct of a sexual nature in relation to the victim of this sexual harassment, engages in it so this is something they also have to include. They do so with the intention of offending, humiliating or intimidating the person, and in circumstances where a reasonable person would have anticipated the possibility that the other person would be offended, humiliated or intimidated. So you'll see here that it's not just unwelcome or unsolicited sexual conduct. There is the acknowledgement that sexual harassment is actually an act of power in this context, particularly in the workplace context. It is not even if unsolicited, an act of flirting or the sorts of things that men all around not just men, people all around the world were saying, oh no, if we make sexual harassment illegal, no one will ever be able to couple up ever again, because if you flirt, it will be illegal. You would have seen some of that sort of ridiculous outcry in relation to the Me Too movement. A lot of people saying, well, if everything is sexual harassment, no one's ever going to get intimate contact with another person again. But here you'll see that the law in Australia actually looks at that idea that it is actually done to offend, humiliate or intimidate, or where a reasonable person would think it may offend, humiliate or intimidate. So it's either done intentionally to do that, or in a situation where a reasonable person would anticipate it. The issue, of course, is who is the reasonable person. Is it the person whose life is flooded with the possibility of sexual harassment? And you'll know that for most women and female presenting persons in our society, the probability of unwelcome sexual behaviour towards them starts very young and is relatively pervasive. Or is the reasonable person a male presenting person who is not catcalled at the age of 12 and consistently treated as a sexualized object? So that can be a tension in this legislation, and something that feminists actually talk about, particularly standpoint feminists who look at the viewpoint of the person who is actually being the person discriminated against here, or the person who is in the less powerful position. And I'm not blaming guys, but many guys don't realise how pervasive sexual harassment is. And there have been a bunch of studies on that where, people ask who's been sexually harassed, and most of the women in a room will put their hand up, and most of the men will be surprised. I've put the names of a couple of cases there at the bottom of the page. There's some of our key cases on the meaning of sexual harassment. In Hill, it's really a rough read. Ms. Hill was someone who was working for New South Wales Water. She was promoted into a managerial position in 1985 over a team of men who did not think women belonged in their workplace and were very clear about it, and who did not think in particular that they should be managed by a woman. She was treated in really quite terrible, gross ways, which included all sorts of nasty sexualized images and comments being made to her, as well as various physical threats, etc. She eventually had to step down from that position and was placed in a demoted position, but without losing the income level she'd been at. And the court actually looked at whether that was an appropriate outcome and said no. They were also looking at whether those acts intended to humiliate could also be this type of sexual connotation, and they said yes. It was one of the very first cases on sex discrimination by virtue of sexual harassment in Australia, and was under the New South Wales legislation. The later case of Poniatowska and Higginbotham was an interesting one. This is Higginbotham Construction. Poniatowska was a woman who worked for them selling their services and their houses, etc. She was in a situation where other sales staff were being particularly sexualized to her, consistently asking her out and making sexual comments about her. Her female manager basically brushed it off and said, well, what do you expect? This is what the workplace is like. She eventually did sue. Part of the defense was that, one, women could not be sexually harassing by taking part in the sexualized comments towards Poniatowska. They said yes, the female manager could, even if she was not doing it for the purpose of her own sexual gratification. And two, saying, well, this is what a workplace is like, and everyone behaves in rough, uncouth, and kind of disgusting ways. That was not a defense. They said that you can't say just because everyone makes sexual comments, that particularly unwelcome sexual comment to one co-worker has to be accepted by that co-worker. And it was relatively gross harassment to Ms. Poniatowska. So just saying everyone behaves in a sexualized way in the workplace is not a defense to sexual harassment. But if you're interested, you can look at the Commonwealth legislation, and there are reams of cases out there. Other things to note is that you're probably all very aware of the Me Too movement, and have become very aware of how people have responded to that. It is becoming less acceptable to engage in sexual harassment, I hope. It is something, there is more support, I think, perhaps for people who are telling their stories. However, do be aware that using alternative legal things such as making comments in the paper, etc., can lead to things like defamation acts, as in the recent Geoffrey Rush case, where, defamation litigation, where Rush sued a newspaper, and the person who had said that Rush had acted in unbecoming ways towards her was made a witness in that case and somewhat discredited by the court. So it can be difficult in situations under the Me Too movement where alternative law could still be used against a person who claims sexual harassment. In addition, I'm very aware of the recent High Court report and investigation into the behaviours of former Justice Dyson Heydon, and that sexual harassment has occurred at the very highest level of legal practice in Australia, with a High Court judge alleged to have behaved highly inappropriately to a range of women, including his own associates and to women that he had met at various events, and that our systems have let down those women and that by individualising complaints, as our current anti-discrimination legislation does, and by making them the subject of conciliation rather than more public and more systemic responses that prevent sexual harassment, rather than only responding to compensate the victim after it had occurred, there is a great deal of critique that can still be made about our sexual harassment law by a range of feminists, particularly those who look to prevent harms and to change our systems to remove patriarchal assumptions around behaviours, rather than waiting to only respond to individualised harms that have happened and treating them as an aberrant behaviour rather than a systemic behaviour. I have seen commentary by our current Chief Justice of the High Court, Susan Kiefel, and she seems incredibly unhappy that this has happened in her court and has committed to such things not happening again. So hopefully there will be a clean broom through our legal profession to prevent and reduce sexual harassment in the future. However, having said that, there again is no systemic approach to sexual harassment as and requirement to prevent it in a systemic way in law firms. So that's our commentary on sexual harassment and sexual harassment in law.